you and let you start the presentation.
Okay. Let's see. And you're doing the PowerPoint slides? Okay. So yep, I'm a staff attorney with the Center for Arkansas Legal Services. I've been here for about 3.5 years, and I was with Legal Aid of Arkansas for 2 years before that. And also did AmeriCorps, which my focus was on reentry. So for that entire year, about 90% of what I did was criminal record sealing. So I've done a few of them. And you can go to the next slide. Okay, so what does sealing do? Why do people want to seal their records? Mainly it's for employment and for housing. It restricts the public access to the criminal record. It is sometimes called expungement. I use those words interchangeably, sealing and expungement. If you really want to get down to it, expungement is what used to occur, where they would actually destroy the records, and now they're not destroyed because certain entities can still view them. And here's a list of a bunch of different entities that can. Generally, when the most common for clients is going to be if they're going to nursing school, the Nursing Certification Board can still see it, or getting a job with schools, daycares, hospital, anything in healthcare. Generally, it's if they deal with at-risk populations, so children, elderly, disabled, then those employers can see a sealed record. But I've had a lot of clients say, you know, I've already disclosed this to my employer and they made a job offer, but they just want it sealed because then they will consider it taken care of. So it, you know, even though they can still see it, that won't disqualify a client from getting a job there. Sometimes they just don't want like their patients or clients to be able to see it. You can go to the next slide. Okay, so what will it not help with? Gun rights is probably the most common that people ask about. Sealing it has no effect on gun rights. The only exception to that is if you are getting the record dismissed and sealed under the First Offender Act, which I'll touch on a little bit further into this. But I mean, the reason they would get their gun rights back is because it's dismissed, not because it's sealed. And voting rights, the defendant just has to complete their sentence and pay off all their fines and sometimes fill out a form at the clerk's office to get voting rights back. They do not have to seal their record. And here's a few others. Back when you could not have a felony and be a guardian, sealing it would not have an effect on it then. Now it doesn't disqualify you either way if you have a felony and are trying to become a guardian. You can go to the next one. So some common issues that happen after it's sealed is when a client goes to apply for a job, and most employers are going to run a background check, which they have to get permission from the employee, potential employee, to run the background check. And the rules for that are under the Fair Credit Reporting Act. When the background check is run and it comes back, sometimes it will still have the record on there that the client has already sealed. And if that happens, then what the client needs to do is request a copy of the background check and contact information for that private background check company, and then contact them, send them a copy of the order to seal that the judge has signed and filed. And then the background check company is required under the FCRA to update their records. If they don't, then the client has a right to file a complaint under the FCRA. And the reason that happens is because when the record is sealed, the order to seal is not sent out, at least as far as I know, it is not sent out to private background check companies. It's placed in the file that is then sealed. And these private background check companies, there's probably 2,000 to 3,000 of them in America. And they are not required to update their records until they have actual notice of it, that the record has been sealed. So that can cause issues because employers will think that the person lied to them, even though under the law, under the sealing law, the person applying for the job can legally state, I have not been convicted of anything if they've sealed all their records. So there is, which I'll touch on a little bit later, there is one nonprofit out in California called the Foundation for Continuing Justice, and they take the order to seal and they send it out to 400, somewhere around there, different private background check companies, and have them update their records. And that is a free service, but I think they offer where someone can pay for it too. I'm not sure. So when you're sealing a record, what info do you need? All of these boxes, these are different things that will go into the petition to seal and the order to seal. So how do you get this information? Well, you want to get the ACIC report. That is the state official background check, but it is private. So on the ACIC report, after a record is sealed, it will still be on the ACIC report, but it will have a box around it that says this record is sealed. And I believe the only people that have access to the ACIC report are the actual defendant, and then criminal justice agencies. And that's pretty much it. Like a judge, the police might have access to it. So there is an ACIC authorization form that we'll show you on the next slide, and it up here at the top, you put the client's name, the designee, that is going to be the attorney's name, and then that box in the middle right is where you put the attorney's name and attorney's address. The client just fills in those boxes on the left, date of birth, etc., and then they have to have their signature notarized. Where it says signature of requesting party. So you'll fax that in to the number here at the top. You should get that ACIC report mailed to you. You should receive it in about 7 to 10 days. If it gets to be like 10 or 14 days and you have not gotten the report, then call ACIC, because this actually happened recently in about the middle of February until the start of March. ACIC's fax machine was down. So any requests that were sent there in the authorization forms, they did not receive them. And so when I called up there, they just gave me an email address and told me to email all the ones I had sent during that time frame. And then they sent the background checks. So once you get the ACIC report, just keep in mind, it's not intuitive at all. It's not always accurate, and it's definitely not always complete. They are just recording info based on what the clerk has sent them, such as like the sentencing order. So here's what it kind of looks like. It's got a bunch of info in there really close together. It'll have the name, and for each different case, it should say arrest number 1 for the oldest one, arrest number 2 will be the next case. And a lot of time, like some smaller district courts, they will not be sending info to ACIC sometimes. So not everything is going to be on there. Sometimes it will just show the charge and maybe what was filed and not have the final disposition. So the charge is what when the police arrest the person, that is what the police charged them with. Filed, a little bit below that, what's filed is what the prosecutor initially files, and then final is what the disposition of the case is. And then you can see below that it has guilty, not guilty, no pros, dismiss. On this one, there's a 1 beside guilty to show that it was 1 count of felony possession of controlled substance. Sometimes it'll have the sentence on there, but that's not super common. And up at the top, on that top part, you can see where it says ATN, kind of in the middle there. On the left, that's arrest tracking number. You do need that number. It will be for each different arrest. You can see it on the bottom part too, over on the right, where it says arrest 1. Then it has the date of arrest, the SID number, and the arrest tracking number. So you need all of that info. The SID number, that's going to be the same for the person their whole life. And the FBI number is also the same for the person. So if you're doing multiple cases for the same client, the FBI number, SID number, those will be the same on all the petitions. They will be different. The arrest tracking number will be different for each different case, each different arrest. You can go to the next one. And here it's zoomed in a little bit more so you can see filed and final are different. So that's because there was probably a plea deal. And so the prosecutor filed for felony aggravated assault, but it was reduced to misdemeanor domestic battery. It also has the disposition date there. And again, all of this information is really good to have, but you do need to look at the sentencing order and verify it because it is not always correct. They are pretty much just copying what they see on the sentencing order. So the ACIC report is not, it's not the final document. You would want to have the sentencing order. That's what, is the final, what it is, what they were convicted of. A lot of times you can get that sentencing order on Court Connect if it's been a recent case. If it's an older one or a district court case, it may not be on there. Sometimes for district court, it is not called a sentencing order. They may call it, they may only have a docket sheet to send you that just has pretty much the same information. And sometimes it's called a judgment and disposition. So I'll ask the client to get it. A lot of times they won't, and it's just a lot faster if I call the court clerk and just ask them to email me the sentencing order, and usually they'll get it to you within about a day. A few courts will want proof that fines have been paid and proof of completion of their sentence from their probation officer. So you'll have to have the client go get that. Most of the time, courts don't require that. The prosecutor will be the one checking up on that. And if they haven't paid their fines, the prosecutor will find out and file an objection. So that's why it's always a good idea. I mean, I always ask my clients, hey, have you paid their fines? They all say yes. And probably about 5% of the time, they have not actually paid it. And that makes the attorney look not so good if you file it and then something as simple as fines haven't been paid. So you always want to verify that yourself. If it's a district court case, you'll call the district court clerk and ask them. If it's a circuit court case, it'll be the county sheriff's office that is where they pay their fines. So definitely always verify that. So here's an example of a sentencing order. You may have seen these before. What I'm gonna point you towards is where it says offense number 2 on the right side. Look just above that whole paragraph there. Defendant committed a target offense and was sentenced under the Community Punishment Act. After completing their sentence, the defendant shall be eligible to have his or her record sealed. And then the next part says defendant was sentenced pursuant to the First Offender Act. and that has the statute for the First Offender Act 1693-301. So that is another, you want to verify the information on the ACIC report, but you also want to check for those two boxes. Were they sentenced under the Community Punishment Act, and were they sentenced under the First Offender Act? And the reason you want to check for those is because those are the main three sealing statutes. The First Offender Act, the Community Punishment Act, and then just the main one is the Comprehensive Criminal Record Sealing Act, 1690-1401. And which petition and which order you will use is based off if that box is checked. You can go to the next slide. Here's another example of a sentencing order. This one's called a judgment and disposition order. You can see where it has arrest tracking number over on the right there. It'll also have the statute of the offense above what the offense was. On this one, I do not believe that there is any anything about the First Offender Act or about the Community Punishment Act. So some sentencing orders will have a box to be checked, some won't. You can go to the next slide. And on this one, so this is probably the most common sentencing order that I see. So where I want y'all to look on this one is up at the top on the left, that second big box where it says legal statements. That's where the boxes are pursuant to ACA 1693-301. So that's the First Offender Act. Sometimes it will only have the statute number on there. And if that box is checked, then that's a good thing because First Offender Act is the best outcome for the client. Now, if you look still on that left page down at the bottom, just to the left of the barcode, you can see another place where it has 1693-301. And again, that box is not checked here. And over on the second page on the right here, down near the second from the bottom big area where it says sentence options. So at the top there, it says Act 531, 1693-1201. That's for the Community Punishment Act. And so here it says they were convicted of a target offense and the box was checked no. And notice that it also says pursuant just below that above jail time credit. It says pursuant to the Community Punishment Act, the defendant shall be eligible to have his or her record sealed. That box is checked no. That does not mean that the client cannot seal the record. So even though that box is checked no, the client may still be able to seal their record. They just can't seal it under the Community Punishment Act. And there is really no difference as far as outcome for the client, and really not much of a difference as far as the standard as to whether it's sealed under the Community Punishment Act or under just the main sealing C.C.R.S.A. But if that box is checked where it says Community Punishment Act, I use that petition. If it's not, then I just use the regular petition to seal felony, petition to seal misdemeanor. You can go to the next slide. So some tips. One thing I always do just about, especially if it's a court I have not filed in before, I will call the court clerk on the phone and just ask to speak to if they have a petition to seal clerk, because usually they'll have one clerk and they handle all of the petition to seal issues. So some courts want you to send in the proposed order when you send in the petition, some do not. Here's a few examples of some weird, I shouldn't say weird, but of some special rules. So in Garland District Court, if you file a petition to seal, 100% of the time, it automatically gets set for a hearing. And It seems cumbersome, but they actually do it pretty well, because they will send out, as soon as it's filed, they send out the hearing notice, and they send it to the prosecutor and the sheriff or police department. And on that notice, there's a box that says, I do object, I do not object. And so the prosecutor can just check that box, send that back to the court, have them file that. And if the prosecutor puts no, I do not object, then normally the judges will sign the order to seal a couple weeks before the actual hearing, so you don't actually have to go. And that way, if they do object, then the hearing's already set. It can delay things just a little bit, but for the most part, it ends up being helpful. Another place, Sebastian County. So they used to require special forms to be submitted when you file the petition to seal. It was almost like a cover page, but it just had tons of information that had to be on there, like driver's license number and a ton of other stuff. But some people I work with actually got that requirement taken away. So that's good. No longer do you have to submit special forms. One issue I actually just a few weeks ago had was with C.C.R.S.A District Court. The clerk there told me I'd mailed in 2 petitions to seal to be filed. One was for driving on suspended license violation, I believe, or it may have been some other traffic violation. And the other one got sealed, but this one hadn't. So I called up to the clerk, and she said, well, we don't have, if we dealt with all the traffic violations and sealed all those, we wouldn't have time to do anything else. So I just went ahead and removed his case from Court Connect and took it off of his driving record. So that is helpful to the client, and it may accomplish their goals, but it could also cause a pretty big issue. If it's showing up on a background check, then the client does not have anything to send that background check company to remove it. So hopefully we can get them to start dealing with traffic violations, but we'll see. And then another rule I just very recently learned was that service, when you're e-filing, service upon the prosecutor is insufficient in petition to seal cases. So if you're e-filing, what they told me was that since it's reopening a case, it's not starting a new case, and the case was closed already, that it does not send a notification to the prosecutor. So Pulaski County is, the biggest county. So with them, they actually have an email set up that you can just email any petition to seal that you filed, just to notify the prosecutor. I think it's seal@pulaskipa.org. So that does make it more convenient, but that's another reason it's a good idea to call the court clerk, sometimes even to call the prosecutor and just check if they're going to get notification, or if you need to mail or email it to them. And another thing, always get a copy of the file marked petition to seal for your records. I had another case where I'm not going to say the court, but I had mailed in 2 petitions to seal they were both misdemeanors, and requested they send me file marked copies of it. They send me back 1 file marked, and they don't send back the other one. But it ended up taking a few months between faxing and emailing just to get it filed. So you always want to get a copy of that as proof. You can go to the next slide. So selecting the correct form, these are all the different types of forms they have. Really, the only ones I use are going to be, well, the no pros one, Act 1460, that's the main one. That's petition to seal felony or misdemeanor. 531 is Community Punishment Act, and 346 is first offender. I don't use the the possession of a controlled substance forms, I haven't had a need to yet. And then the DWI forms are new because they have changed the wait period on DWI and BWI. So here's what ACIC's website looks like. And the main ones you're going to use are petition to seal felony, order to seal felony, same thing with misdemeanors. But they're all grouped in one place on the page there. And here's the main three statutes I've been talking about: First Offenders Act, Community Punishment Act, Comprehensive Criminal Record Sealing Act. The only difference is with the First Offenders Act, it's actually dismissed and sealed. With the other two, they're basically the same as far as outcome. You're just going to look at the sentencing order to see if it's Community Punishment Act or First Offender Act. So for misdemeanors, here's just kind of the basic rules. They can be sealed immediately. Everything has to be paid off. They do have to take classes if the court orders them to, and they do have to have their driver's license reinstated if it was suspended. And there is no limit on sealing misdemeanors. You can seal an unlimited amount of them. So there are 7 misdemeanors that have a longer wait period. These first 6 have a 5-year wait period. DWI and BWI has been amended to the look-back period, which under the DWI statute, it says that is 10 years for DWI, I think 1 through 5, which at 4, it becomes a felony. And just kind of an interesting thing that I also learned recently is that that's only for DWI misdemeanors that there's a 10-year wait. For DWI felonies, there is no wait in the statute. So that law might change soon. You can go to the next one. So what's the procedure? You file the petition to seal and probably the proposed order to seal, mail that into, or e-file it. The prosecutor has 30 days to file an objection. They have to say why they're objecting. And if there's an objection, then a hearing has to be set for it to be decided. The standard is clear and convincing evidence that the record should not be sealed. So that burden is on the state. That's a pretty high burden for them to meet in most misdemeanor cases. Really, the only thing you're going to be looking at is if whatever they were convicted of, if they have gotten within the last, say, year or 2 years, if they've been continually just convicted of the same thing over and over, then the prosecutor and judge may want the person to wait a couple years before they think that that it should be sealed, that it's in the interest of justice. So also, so this case just came out, Talley v. State, and what they analyzed was the prosecutor did not file an objection within 30 days. I don't think they filed one at all. And so the petitioner argued that, well, they don't get to have an objection at the hearing either. And the judge said no. And the Arkansas Court of Appeals agreed with them that it doesn't matter if they filed it within 30 days, they can still show up at the hearing and object to it. That's just kind of a, I guess, more like guidance. You can go to the next one. So with felonies, the main thing to look at, you can only seal their 2 oldest felonies. If they have 3 or more, you can still seal those 2 oldest ones, but any after that cannot be sealed. The only exception is if their first one was sentenced under First Offender Act, then it's actually dismissed. So then you can get the next 2. If they have a lot of felonies, then that may cause the judge to even deny those first 2 that you're trying to seal because they may not consider it in the interest of justice. So here is a list of just kind of the rules for sealing felonies. You can find these in the statute too. You can only seal Class C or D felonies, you can only seal Class A or B felonies if it did not involve violence and was a drug-related felony. If it's a Class C or D, that's a violent felony. You have to wait 5 years, and you cannot seal any Y felonies. So this used to be a rule. They removed it in July 2021, I believe. That it may have been in 2020. I don't remember, but serving time in ADC used to automatically disqualify a person from sealing their record. No longer does that disqualify a person. But the reason they went to ADC could still disqualify them. A lot of times on the third felony, they're going to get sent to ADC, or if they have a revocation of their probation, they may be sent to ADC. So those are reasons, or if it's like a Class Y felony. So you want to look at the reason they were sent to ADC. That's kind of a yellow flag now if that comes up, and you want to, investigate further. So what cannot be sealed, like I said earlier, no Class Y, A and B can only be sealed if it's a drug felony. This doesn't come up often, but you do need to remember it. A felony traffic offense cannot be sealed if the defendant was a holder of a CDL, a commercial driver's license, at the time the offense occurred. If they get their CDL 6 months after, then they should still be okay to seal it. Let's see, and if the felony is unclassified, you're going to look at the sentence. If it's greater than 10 years, you cannot seal it. If it's not, then you should be fine. Here's just some examples of felonies that cannot be sealed. As you can see, they're all sexual or violent. And the legislature has been pretty clear they don't allow any sexual felonies to be sealed, and only Class C or D violent felonies, but they have that 5-year wait. So what's the procedure? So with felonies, there's no actual specific time limitation for the prosecutor to respond. And the judge can grant or deny the felony at any time after that initial 30-day period elapses. I've had probably a couple cases where it's gone quicker than that. One case, actually, I e-filed a petition to seal a felony. It was the client's only felony. And in an hour, the order to seal was signed and filed. So sometimes they can happen a lot faster. Okay, this line is not, I was looking at the statute yesterday, it's not exactly correct, where it says must have a hearing even if the prosecutor decides not to object. The way I read the statute is if the prosecutor objects, then you must have a hearing if the petition to seal will be granted. If there's no objection, then definitely in practice, I've never had a circuit court judge require a hearing if there's no objection. The main thing is a lot of circuit court judges are not going to do anything. They're not going to make a decision until the prosecutor responds. So you just want to make sure that the prosecutor does know that you filed this, and try to get them to respond. Sometimes they won't, and the case will be sitting there for months, and you've called the prosecutor a couple times, they won't respond. You don't want to keep blowing their phone up. So if that's the case, you just schedule a hearing, and sometimes that'll get signed before the hearing, sometimes not. The standard review, again, is clear and convincing evidence, but the burden is on the petitioner. So clear and convincing evidence that granting the petition to seal would further the interest of justice. So what does it mean, further the interest of justice? Well, the statute gives you 5 factors. They're not exclusive. The judge can really look at whatever they want. For the most part, these factors kind of all mean the same thing. What was the person's other criminal history? Did they commit offenses after they were convicted of this first one that you're trying to seal? And then any other information provided by the state that would cause a reasonable person to consider the defendant a further threat to society. Again, that's probably going to be other convictions or arrest, or you can just imagine the different things. I've never actually seen where a victim has provided input, and I'm not really sure how that would occur, because the victim doesn't receive notification usually that this has been filed. So it would be only if the prosecutor, I suppose, got the victim to come to court for the hearing. So sealing arrest, they can be sealed. You have to wait 1 year from the date of the arrest if no charges are filed. So you'll file it usually in the circuit court, but not always. I think it depends if it's a felony or misdemeanor as to whether that they were charged with by the police, as to whether you file in circuit court or district court. You can use the arrest tracking number as the case number. Usually I ask the clerk or the prosecutor or both kind of what they think. Sometimes I just leave the case number blank. And so because there's no case number, the clerk is opening up a new case for the defendant petitioner. And one court, this was probably 4 years ago, they would actually require the petitioners to pay $165 because they were opening up a new case in circuit court. And we were able to get that requirement removed just by showing them the statute. But one thing to keep in mind with arrest, so I'm doing a case right now with trying to seal an arrest. And so I talked to the clerk and they were super helpful, but they said, well, we just, they called the police and verified that there was the arrest, but the clerk just had zero information about the arrest. And so the clerk asked me to contact the police and get just some sort of document that shows the date of arrest at least and what they were arrested with, and to file that with the petition to seal. And that's because they just had no information at the court on it at all. So those can be tricky, and you definitely want to talk to the clerk and see if you need to get them more information, get the court more information. Otherwise, they won't even know about the arrest. And the standard is unbelievable. It's so low. It's very, very easy. I don't think I've ever seen an arrest denied. So with nolle pros, you do have to wait 1 year from the date of nolle pros. Dismissal, you can do it immediately. Just make sure, like if it's an acquittal, it cannot be for a reason of mental defect or disease. If that's the case, you cannot seal it. I believe I had an applicant that wanted their gun rights back. And they were like, I was acquitted. Why don't I have my gun rights? And I looked at it and they were acquitted because of mental defect or disease. So they cannot seal it. And even if they could, that would not restore their gun rights. And again, the standard's very low on all of these. So if it's denied, how long do you have to wait? Misdemeanors, it's 90 days. Felonies, it's 1 year. And the misdemeanors that require 5 years, those 7 violent ones, you have to wait a year before you can file another petition to seal. Sometimes it's worth doing that. If the prosecutor just wanted you to wait a while because of very recent criminal convictions for the client. But if it's denied because the judge says, well, I don't have the authority to seal this because it's their third felony or it's a class Y, then there's no reason to keep badgering them and keep filing it. Okay, so here's a little bit on the First Offenders Act. Let's see, there's a few requirements. Those aren't super important for you to know if you're sealing. You may have to fill in a few blanks on the petition, such as how long their probation was, has to be over a year. I think the fines have to be under $3,500, but if they're over $3,500, I don't think that would disqualify them from sealing. But the main thing is they have to be specifically sentenced. That box on the sentencing order has to be checked, or somewhere it has to say Act 346. I have had a case where on the sentencing order it was not checked, but on the judge's docket sheet it said Act 346, and that was the only place we could find it. So we were still able to use the First Offenders Act. Let's see. But you can only use it once. I have seen it used on misdemeanors before, but usually a client would want to save that for a felony. And again, you can only use it once. It's a felony if you attempt to use it more than once. So with the First Offenders Act, sometimes on Court Connect, up where it shows what they were convicted of and it says guilty, it will say deferred, because they're actually not supposed to be adjudicated as guilty. It's just a deferred sentence. If they mess up on their probation, then they're going to be found guilty and probably sent to ADC. If they complete their probation successfully, then the case will actually be dismissed and sealed upon the petition by the defendant. Since there's no conviction, gun rights could be restored if that's the only thing that was preventing them. There is one court case, I forget the name of it. I think it was from around Russellville or Pope County, something like that. And the person was sentenced under the First Offenders Act, and I think it was like 3 years of probation. So 2 years into the probation, they get in trouble for something else, and their probation gets extended another 2 or 3 years. And then they complete that, and they file a petition to dismiss and seal under the First Offenders Act. And the judge decided, well, I'm going to seal it, but I'm not going to dismiss it because you had a revocation. The revocation, they were actually not found guilty of the revocation, so maybe it wasn't even extended. But the revocation petition was filed, and the prosecutor and judge thought that that was enough to prevent the defendant from getting it dismissed. And I believe that decision was upheld by the Court of Appeals. Community Punishment Act, again, there's a list. If you go to that statute, there's a list of the different offenses. But basically, you're just looking on the sentencing order and seeing if the box is checked next to either the statute number, either Act 531 or CPA, Community Punishment Act. One helpful thing is under the main sealing statute, C.C.R.S.A, there is no definition of violent, but under the Community Punishment Act, there is a definition of violent. And there's one specific conviction, I believe it's terroristic threatening, that the language of that statute matches the language for if something is violent. But they recently made it a target offense. I believe it was recent. And so I had a coworker that actually got the judge to agree that it is not violent because of the recent change to the legislature made that put terroristic threatening in the target group. So that one's kind of tricky. It used to allow residential burglary under this Act 531, but they took that out. So it no longer is allowed under the CPA. You can go to the next one. Okay, so revocations. There's one really good case on it. It's State v. Brown, and the numbers on that are 2019 ARC 395. And basically what it says is when there's a revocation, generally they're not going to be able to seal it because they did not successfully complete their sentence. But what you want to look at as the attorney is look at the post-revocation sentencing order, and you are going to look to see if it has that language that says defendant shall be eligible to have their record sealed. It's not always on there, but sometimes it is. If yes is checked, they definitely can seal it. If no is checked, then State v. Brown says no, it cannot be sealed. If both boxes are unchecked or there is no box for it, which is the majority of cases I've seen, then it's up to the judge's discretion. More likely it cannot be sealed unless if it was something like failure to pay. And then the attorney could argue that lack of income should not prevent someone from sealing their criminal record. But, you know, it could. It's really up to the judge on that. So tips for hearings: do respond with, if you get an objection from the prosecutor, file a short reply brief. It may make it easier for the judge to kind of see what your arguments are ahead of time. At the actual hearing, in my closing, I always mention effects on recidivism, that, you know, the number one factor as to whether someone is going to go back to prison after they've gotten out is whether they gain employment. And by sealing their criminal record, it vastly improves their chances of gaining employment. So by sealing the record, they really are lowering their chance of committing more crimes. You can go to the next one. Okay, and then just, let's see, is this one you, Abby?
Yes, sorry, I was unmuting. Yes, all right, so I'm gonna take over for the last couple minutes. Woohoo, I'm gonna bring us past the finish line. Okay, and I know there's some questions popping up, and I think we're gonna have a little bit of time to address those when I get done here, because this won't take very long. Okay, so I just wanted to cover a couple of the hiccups that might happen, some things that you might run into when you get out there and start doing these record sealing cases. And some of you I know have already done this, so you're already aware. But for those of you who haven't, so you're going to have cases that originate in district court, and then they get bound over to circuit court. So what you do is you just seal it in circuit court. The clerk is supposed to send that order to the district court, but they don't always know that. And I've quoted the statute there. It says pretty clearly what they're supposed to do, and this is their responsibility. But in my experience, and I know in Ryan's too, a lot of times they don't know what to do. And they're like, well, maybe aren't you supposed to file it also in district court? Or like, they'll try to make you do something yourself. Usually they do suggest that you just file it in district court. But I would encourage you that if this happens, don't give in and just do that. Like, do your best to communicate with them, and, you know, suggest maybe they talk to the TCA, maybe get some, input from the judge or something, so that they start doing this. And we did this in Garland County, and pretty quickly the clerk was like, okay, yeah, I think you might be right. Let me talk to other clerks about it, and we might change our policy on that. And I can see how someone might just want to be like, oh, fine, whatever, I'll just file it in district court. I'll file another case in district court to seal that. But you really don't want to do that, because what happens is a person comes along doing this pro se, and they don't know what to do at this point. And they did everything right and they sealed their case. And then now they're stuck with this district court case there, and they're having to figure out how to get that gone. And they don't really have the same ability to talk to clerks and people in the courthouse like we do. They don't, you know, people don't, from what I've seen, give them as much like credibility. So we really want to, I really would encourage you that if this does happen, try to get the clerk to do it the right way so that this doesn't keep happening. Okay, so what else? Warrants is another one. So sometimes warrants will have a separate case number and show up on Court Connect as if it were its own separate case. This is very annoying. So when the court seals a criminal case, the clerk probably won't remove this warrant. And this is what it looks like. I know this is like public information, but I just felt bad putting this guy's name up here, so I redacted it. But John here, so he had 63 SW, that's the search warrant. That was opened up March 31st, and then the criminal case was opened up April 1st. So I didn't even look to see if his case is something that's sealable. So it might not even be something that would be sealed, but it doesn't matter. It's just for an example. Okay, so the statute does say that the warrant is supposed to be sealed, and I'm pretty sure that the warrant usually goes inside of the criminal case docket. It's just that when there is no criminal case, they put up the search warrant as a separate case. So just to make it a little more clear, what happens is you've got this case up here that you may have sealed, but then you've still got this search warrant that's up there. And you can see there's a hyperlink on warrant. Oh my gosh, what happens if we click on the hyperlink? Ah, oh my goodness. So here we are, and we sealed our client's case. Maybe we sealed it in circuit court, and then you know, had trouble getting them to seal it in district court. And then now here we are, we still got this pesky warrant with this warrant affidavit that describes exactly what happened in the case we just sealed. What a bummer. And you can see here, well, you might not be able to see because it's really small print, but it says evidence related to possession of controlled substance with purpose to deliver. And it talks about the police finding baggies of clear crystalline substance suspected of being meth. Okay. So this guy got his record sealed, and think of it this way. You could have a case where old John or whoever was never even convicted of the criminal case, where he just, it was no pros, or it was dismissed, but there's still this affidavit for a warrant that's up there. And so in these cases, someone might take a look at this and think, oh, he was probably convicted. They might assume that he was convicted when he never even was in the first place. So in that scenario, you can see how record sealing without sealing the warrant, in addition to the underlying criminal case, when it's separately docketed like that, could actually be more detrimental. So how do we take care of this? Well, there's some more of the law. It just talks about, you know, documents related to the record. They are excluded from public access. They are confidential absent a court order, and that includes the warrant. So you cannot file in a search warrant case. You can go on eFlex and look all you want. You're not going to see anywhere where you can file unless something's happened in the last like month or two. So what do? You send your motion or your petition to seal and your proposed order to the TCA, write them a little, you know, email, hey, you know, get this to the judge when they've got time. And in my case, and I know a couple other attorneys who've done it. This actually wasn't my idea. I got this from another attorney. So what usually happens is they'll seal it pretty quickly. I haven't seen so far a judge not do that. I'm sure they would in some cases, but really the warrant is supposed to be sealed along with the case. Oh yeah, down here at the bottom, I made a little note. Could you take care of this on the front end? I don't know, but it certainly sounds like a good idea. Like if you could edit the form petition or the form order that you get off the ACIC website, which usually I think a lot of courts require you to use those forms. But if you print that off or not print it off, but if you download and edit it to refer specifically to a warrant that has a separate case number, then maybe you wouldn't have to do another motion at the end. Maybe you would just have to, you know, maybe you could just file that and the clerk would seal it. I don't know, something to think about. Okay, finally, I've got 2 minutes left. Okay, civil forfeiture cases. Now, I know what you're thinking. You cannot seal a civil case in Arkansas. There's no statute to seal a civil case, and that's correct. However, I have sealed a civil forfeiture case, and it's because there were all these like perfect circumstances that just led to it happening. Okay, so what did I argue? I basically used the same argument I used for the warrant. I said, hey, it's related to the underlying criminal case. It wouldn't have even existed if it weren't for this criminal case. And furthermore, it says exactly what happened. It says how they got arrested. It says what was found on their person, et cetera, et cetera. And this administrative order says that this information about a case that's been expunged, it's confidential. So this should be sealed. And also think about it. Same thing like with the affidavit for the warrant. You've got all this detrimental information about your client and what happened to them in their criminal case that's now sealed, but the information's still out there through this civil forfeiture case. Because in a lot of these cases, it'll say pretty much the same thing that's in the affidavit for warrant. So you could have a civil forfeiture case just hanging out there on, you know, a public access website that says, yeah, we arrested so-and-so with 69,000 pounds of methamphetamine, and he had it in the back of his Bronco and or whatever. And maybe, like I said before, potentially the underlying case was dismissed in the first place. He was never convicted. But folks will look at this and not understand that. And your client, this could affect their employment opportunities. This could affect a lot of things in their life, like Ryan has already discussed. And so it's important. It's important. And so I know that the statute doesn't technically allow for a civil case to be filed, but there is a little bit of an argument that you can make, and it did work in my case, specifically because the prosecutor did not object. The judge did tell me, he said, hey, if the prosecutor was objecting, I probably wouldn't seal this. And I was like, hey, now, I understand, but he's not. So, and then he sealed it. One more point, or just a little example. This is a little bit distorted because I blew it up so much. But this is actually language from the order to seal that I filed in the forfeiture case. And if you want to take a look at that, just let me know, send me an email, and I will send you a copy of, you know, of whatever I filed with the names redacted and whatnot. So that is all. And we really don't have time for questions, but I will